Next case is Kimberly Marie Marik versus Peter Brian Marik. Could you please wait a moment till we clear the audience? Okay, go ahead, please.
Scott Bassett, appearing for the appellant Peter Marik. I'll waive any fire-free zone. I'm not going to reserve anything for rebuttal.
It's the best opening of the day.
Thank you. This should be pretty straightforward. It comes down to what do we mean by custody, and secondarily, what do we mean by affects custody? Well, the Court of Appeals in the Ozimek case, which Ms. Argeroff will argue when I'm done, that was the basis for the dismissal in my case, the Marik case. And what the Court of Appeals did in that case was essentially say that legal custody is not real custody. They took a look at the final order rule and the language that this Court promulgated in 7.202-6A3, where it says post-judgment order affecting custody is a final order appealable by right, and they somehow presumed that this Court could not have meant legal custody. That's kind of strange because the last two times this Court has looked at what is custody were a couple of cases, one of which I was involved in, AJR. It was a step-parent adoption case, and that was actually based significantly on the Grange case that came before it, both of which looked at custody and what does it mean. And these cases, I think, are emphasized more in Ms. Argeroff's brief in the Ozimek case than in mine. But this Court said custody has two components. It really always has. Even before the joint custody statute in 1980, you go all the way back to case law in the 30s, and custody has always meant legal and physical custody. There is the shared decision-making, legal custody, and that's the way it's phrased in our statute. And then there's period of residency, which is physical custody, and they're both custody. There is nothing in any statute in this state, in any court rule in this state, and in no case before Ozimek, that creates a hierarchy of custody that says physical custody is more important than legal custody. It doesn't exist. The Court of Appeals essentially invented that out of whole cloth in its Ozimek decision. Now, why would legal custody be as important as physical? You think, yeah, the kid lives with me. That's an important thing. But decision-making is critically important as well. We have a whole line of cases from the U.S. Supreme Court to our appellate courts, ticking off the major areas of importance. I think by consensus they've generally been viewed as things like health care, religious upbringing, and education. The cases before you today involve one component of that, education. They're both school enrollment cases coming up post-divorce, post-judgment. Now, at the U.S. Supreme Court level, we've got cases such as, Prince and Meyer versus Nebraska, and all of those that talk about the importance of decision-making on behalf of children. That's a legal custody issue. It's always been considered a fundamental right, and it's always been considered of critical importance in this.
So if we agree with you and we say custody means physical custody and legal custody as we use those terms in Michigan, when do you get an appeal by right? So, for example, a parent brings weekly motions to court to change the school of the child, and weekly the trial judge denies the motion. Do you get an appeal of right every time that happens?
Well, you do. Let's not confuse jurisdiction versus whether the court has the power to sanction inappropriate conduct.
Well, let's focus on the word affect. If there's no change, does it really affect the custody?
Well, all of our case law up to this point has said yes. If you take a look at...
We can look at it afresh, right? We can look at it...
You absolutely can. But you should take a look at what the Court of Appeals has done consistently for decades, all the way up until recently. Look at cases like the Granneman case. In that case, what they looked at is any decision made by the court when it's asked to do something that would affect custody, whether they grant or deny the relief, still has an effect, and they resort, it becomes a dictionary exercise then. What does effect mean? And they resort to Black's. Black's ninth says effects means influence. A denial of a request for a change in health care, education, school enrollment, all of those affect the legal custodial rights of the parents involved.
Why is that right? I mean, I feel like I agree with you. As a matter of first principles, custody has to include legal custody. That almost feels like the easy part. And I imagine everybody would agree that if on some motion about a school change or something else that's clearly something that parents who are both legal custodians have a vote in and they can't come to terms with, so they come to a court and the court says, I agree with mom's position. Tomorrow, if they have a different dispute about travel soccer and the court agrees with dad's position, they still the next day each have the same legal custodial voting rights, right? So how is their legal custody changed just because they had to have this particular dispute, worked out by the court? The next day they still have that vote, that legal custodial vote.
Well, Justice McCormick, I guess the way I would answer that is it does very little good to essentially give lip service to parental legal rights to participate in decision-making when they then try to participate in that decision-making and the court enters an order favoring one over the other, so you have an aggrieved party.
But they both participated. They just couldn't resolve it, so the court had to resolve it. It's not, I sort of feel like if the court were to say, I think mom's right about travel soccer. We're going with travel soccer. And by the way, I can't believe this. I can't believe, Dad, you think travel soccer is a bad idea. You no longer have legal custody at all. I now think mom should make all decisions because you obviously can't make decisions. No more legal custody for you. That feels decidedly different than, travel soccer, right? So no legal custody at all. I get that right now that might not even be appealable as of right and should be, but those seem different to me.
Well, is it different though to say that somebody has a right to participate in a decision, and then when they try to exercise it, tell them that they then no longer have a right to appeal it when they're aggrieved from exercising that decision? What you're basically saying is
they still have the right to seek leave, though.
They have the right to seek leave, but that is not in recognition of the fundamental rights that we've always recognized these decisions involving. If you take an unbroken string of cases from the original Lombardo case, which was the first school enrollment case back in '93, now that preceded the existing court rule by a couple of years, but then you take a look at Parent, a case decided by this court, all the way forward. All of these school enrollment cases, all of the medical decision cases, all of the religious upbringing, well, Fisher was pre the existing court rule. That's the most prominent religion case. All of those were considered to be important enough and were recognized by the Court of Appeals as an appeal by right. Justice Zara, I think it's important to point out kind of how blindsided the family law appellate practitioners viewed this change in the Court of Appeals. I mean, this came up suddenly. It came up last year. We had decades of an unbroken string of recognition that affecting custody included all of these important legal custody rights, like school enrollment, and then all of a sudden it changed. We haven't been able to figure out the reason. One of the arguments made by Appellee is our position would open the floodgates. There really isn't a floodgate to open. Now, it's not easy to come up with precise statistics on how many custody cases end up in the Court of Appeals. But in looking and doing a search for, custody issues in DC and DM cases, now they may come up in DP cases as well, but at least limited to DC and DM, we see what's going on there is there's anywhere from like 35 to 70 over the last 5 years, depending on the year. It's not a floodgate of cases. And some of those are before the Court of Appeals changed its policy and started dismissing these cases administratively. And then from 2016 forward, because this happened fairly early last year, through this year, and we don't really see any change in the numbers. This is not a case where we need to spare the courts the burden of dealing with these cases. What it is a situation where we need to recognize the fundamental rights that these parents have and recognize that they ought to have an appeal by right. If we take a look at what other things are appealable by right, two subsections later in the same final order rule is the attorney fee provision. Costs and attorney fees are appealable by right. There is no placement of you have to have a certain level of importance on those. There have been people who have appealed for $500 or less and claimed an appeal by right under that same final order rule. It's just two subsections. It's 6A5 is the attorney fee provision. So it's not as if we're setting up that these cases are somehow unimportant. There are certainly far less important cases that are getting an appeal by right under our court rules, and these are critically important cases. For example, legal custody now, after the enactment of the residence rule, the 100-mile rule, 722.31, a parent can't even challenge a parent who wants to take their child to California or Australia, for example. We just had a case like that. Unless they have a share of legal custody. That's how fundamentally important this is. They can't even go in and ask for a school enrollment decision unless they have a share of legal custody. These are all fundamental rights. We take a look at what's happened at the federal level, with the case out of California, with, the Pledge of Allegiance. If a parent doesn't have legal custody, they can't be involved in their child's decision whether to stand or sit for the pledge.
Nobody disputes that your client has legal custody. That's not an issue. Your client has legal custody. Your client can bring the Pledge of Allegiance case if your client were an objector. So, so that's not, I think what Justice McCormick is trying to get at is having legal custody means the right to participate in decision-making about your client's child. And by definition, if there are two parents who have shared legal custody and they can't resolve the dispute themselves, one of them is going to lose. So the only question for our court is, does that mean they lost legal custody or their legal custody was affected because they lost in a dispute over the exercise of that custody?
And they might win the next day. They might lose soccer, and they might win Chinese lessons, and then lose,
And if we're going to honor
people.
but if we're going to honor the fact that these are important decisions. If you take a look at the joint custody statute itself, it talks about sharing important decisions. So if we're talking about, I'm not sure travel soccer rises to that level, but things like school enrollment clearly has historically, at least under our case law. So I think it does not honor the fundamental rights involved to say that these cases are not important enough to justify an appeal by right.
But our question isn't whether or not we think they're sufficiently important to justify an appeal of right. Our question is, what does the rule say about whether or not?
What does affecting custody mean?
Yeah, what does affecting custody mean?
Affecting
That's what
custody
we're trying to figure out.
Affecting custody has always meant up until, Ozimeck's kind of an outlier because it simply says that legal custody isn't custody. So I guess we have to set that off by itself. But if we take a look at every other decision that has looked at affecting custody, they have said that things like school enrollment, things like associational decisions like the Granneman case, which was a grandparenting time case, all of those affecting custody has always included whether you win or lose, whether the order has changed or not been changed by the trial.
Isn't the grandparenting time case distinguishable because there the father had sole legal custody?
And sole physical
and
custody.
Sole physical custody. And then if you give the grandparenting time, he has lost some of his sole physical custody. It's not like he's got part and mom's got part originally, and then she says, I want time with the grandparent.
But we're still talking about a parent's exercise of fundamental rights. You're still going to have that in a case of joint physical custody like we do in Marik. It's still, my client has an independent right to argue for his school enrollment preference for his
Sounds
children.
to me like you're arguing that your client has a constitutional right, maybe, to appeal important parenting decisions. So, in other words, if this rule said there shall be no appeal of right by leave, there shall be no appeal, you would say that was unconstitutional.
I had never thought about it that way, but I think it probably would be. I mean, I hadn't even contemplated that we would ever have such a rule.
Well, because the rule says affecting legal custody, and if we were to believe that you still have legal custody, even when you lose a dispute about the exercise of that custody, it sounds to me like you would say no, not with respect to important decisions. Travel soccer, maybe, although let me tell you, having a son who plays travel soccer, that's an important decision if you're going to do or not do that.
Right.
But in any event, it sounds to me like your argument is slightly different than does this affect legal custody?
No, I'm still arguing that this does affect, well, the actual term would be affect custody. Legal is not in there.
Affect
what we're
custody,
saying is
yes.
that legal includes legal and physical. I guess what I'm saying is every court that's looked at, and again, it's your rule. You can interpret it the way that you see fit. But every court that's looked at it before, from the trial courts to the Court of Appeals here, has said that affecting custody, it's not, affecting custody is not a defined term under Michigan law, so let's resort to, dictionary and common usage. Dictionary and common usage says influence. And influence means, grant or deny. I mean, it doesn't matter who prevails on something like that. Either way, it affects or influences the custodial arrangement. Okay, thank you.
Thank you, counsel.
Good afternoon. May it please the court. Susan Lichterman, and with me is my partner, Brian Shannon, and we represent the appellee, Kimberly Marik. And I think Justices McCormick and Larson hit it right on the head when they say the issue is not what custody means. We agree that custody is legal and physical, one or the other. The issue is whether it affects custody. And I submit to you, Your Honors, that legal custody is shared decision-making, and a component of legal custody that most people agree to. Unfortunately, in my view, I think we do it as a matter of course in almost every divorce judgment without really thinking about it, but a component of it is if you can't decide, then the judge decides. That's a part of legal custody, and it's exactly as the justices said, that for that one decision, in this case it was should the children stay in the same school that they've been in for 5 years, the judge called it. But the next decision, when they start middle school, what pediatrician they're going to, should they see a therapist, those are all still joint legal custody decisions that these parties have to make together, and that these parties have to agree on or the judge decides. And I would suggest that if that's not working, if they're repeatedly coming back to court, then what do? One of them files for sole legal custody, and then that decision, whether granted or denied, would absolutely be appealable by right.
So given that you agree that the Court of Appeals got at least that much wrong in Ozimek, you think legal custody is custody?
Oh, absolutely.
Okay, so we should fix that in the Court of Appeals opinion if we do nothing else?
Yeah, but I don't necessarily think that we read it as a change in. I think you can read Ozimek that they are saying that if there was a change in legal custody, an actual motion to modify legal custody, that would be appealable by right. I didn't read it to say that doesn't affect custody because now you're losing. I read it to that a single legal decision is not appealable by right. But, of course, if the court, it's your rule, as Mr. Bassett said, and if the court reads Ozimek to say, I do agree that certainly if a court took away or either, and I agree also with Mr. Bassett that historically it was whether it was granting or denying a change of legal custody, not simply changing it. What the request. And I think we can also agree that it's what effectively happens. So we don't leave it to our practitioners to define the motion, and you see this file a motion for change of parenting time because it's a lower burden under the shade standard and that we could maybe get through it. But if it's effectively a change of custody, that too could be appealable by right.
I just jumped right into your free fire zone.
That's fine, and I meant to say I'm fine.
Since I started, I'm going to keep at it. So now maybe I'm arguing with myself in my own head. Welcome to my world. What is there any? Help me. Do you think there is any like legal custodial dispute that might rise to the level that even you would want to say, "Gosh, I think a court should review that." So travel soccer might be on one end, or rec and ed soccer might be on one end, but on the other end, the parents disagree about what religion, to raise their kids in. Do you think there's something more fundamental that that we might want to think about, that might cause us to think about this question a little differently? Are there any decisions that fall into that?
Well, I think just like a parenting time decision that could effectively change physical custody, there are joint legal decisions that could effectively change physical custody as well, affect custody in such a way that it would be appealed by right. For example, a school decision when the school is 40, 50, 60 miles away.
Well, I get that. I get that any legal, I feel like any legal custody dispute could seep into a physical custody dispute. Even travel soccer could, frankly. Travel soccer, if I lose travel soccer and then my kid is in Traverse City every weekend, it becomes a physical custody problem. So any good lawyer can probably plead a legal custody dispute as a physical custody dispute. But I just meant to be asking the pure question of, is there any fundamental legal custodial dispute that you think the entire bar would say, we think this should be appealable as of right? Like religion is the one that comes to mind. There might be others.
Well, I think as a jurisdictional standard, using the word an important decision is appealable by right, and a non-important one isn't really manageable. And I think that's why we have to put trust in our Court of Appeals and the application process. And I think if an important decision that everyone, the entire bar, could agree upon, that came a religion decision that mom or dad suddenly as a result of religion is not giving child appropriate health care, and there is such abuse. First of all, I hope the trial court would get it right on that level, but if the decision is so important, we have to put trust in our application process that application would be granted. And as we point out, most of these joint legal decisions have to be decided very quickly. There really isn't time for the appeal of right, even the expedited appeal in custody cases to take. In this case, for example, we're now a year and a half later, but in order if the child wanted to enroll the child in school by September, the motions were heard in June, and then the appeal of right was filed 21 days later. And if the request was really to get this done, it would have had to have included an emergency appeal, motion for immediate consideration, so that the Court of Appeals, and the distinction in an application and an appeal of right under those circumstances is not a great one, if anything at all. And that's what our commissioners are hired to do and what they're trained to do. And often the applications are denied for lack of merit, and they do a thorough review of the application. So I have confidence in our system.
So the leave system would take care of the case that I might be worried about?
Correct, because I think it's really a small case. I think the bigger problem is the whether travel soccer is important or not, but the list goes on. The pediatrician, the therapist. I recently had a case where the parents were arguing over whether the child should be allowed to wear high heels. And you...
No, the answer is no.
Counsel.
Should it be appealable by right, though? I would say... I would
Depends
say
what the ruling was in the trial court.
I would say it shouldn't be.
Perhaps I'm misinterpreting something you're saying here, but aren't you effectively interpreting the phrase affecting custody in a distinctive fashion in legal and physical custody cases in which nothing has occurred beyond maintenance of the status quo? Seems like you're interpreting what it means to affect custody different in those two categories of cases. You're saying they're both included within the statute, but that there's only an appeal by right with respect to physical custody cases, even though nothing has changed the status quo.
No, I don't believe
I thought
it.
you said that you thought there was an appeal by right in the cases that we're looking at here. Is that right?
I believe there's appeal of right
In physical custody cases.
in a motion. I also believe there's appeal of right if there is a motion to modify legal custody.
That's granted.
Is granted or denied. If the actual motion is to change from sole legal to joint legal or from joint legal to sole legal, that would be a change that would affect custody. I don't believe there's appeal of right of a single legal decision when after the decision is decided by the judge, essentially the tiebreaker, that you still have joint legal custody. So your custody rights were not affected.
Well, your custody rights were not affected because the status quo was maintained, right? Nothing happened. Nothing happened to change that status quo. Is that right?
Because you still have joint legal custody. In the example about physical custody, you don't still have. They changed the custody.
But what about those physical custody cases in which a motion to change or alter that physical custody is not granted?
Historically, and I don't disagree, that would be changing long-time precedent that we look to the relief that was requested. So if the requested relief, whether it was granted or denied, would have changed custody.
I guess that gets back to my initial question. Aren't we applying a double standard to what it means to affect custody in those two category of cases? In one category, we're looking at affecting custody as actually resulting in the alteration of custody, and in the other class of cases, we're saying that no, that alteration of custody is not a condition precedent to an appeal by right.
Oh, I think I now understand your question. No, because the argument that in the legal custody cases, regardless of how it's decided, it didn't affect custody. Had the Marik children, had Mr. Marik's motion been granted and they be allowed to attend public school, it wouldn't have affected, they still would have had joint legal custody. So regardless of which way the decision went, it didn't affect legal custody. So unless I'm misunderstanding, Your Honor, I don't think I'm arguing at all.
I'm not being clear because I'm still puzzled by that.
Is it the custody of the children or the custody rights of the parents that are affected?
It is the custody is the right of the parent, not of the child.
But when we say affecting custody, isn't it the children that are affected?
Well, if that is the standard, almost any post-judgment case involving minor children affects the children, and we've already, parenting time cases affect children. The court rule does not say affecting the minor. It says affecting custody of the minor. So the fact that everything affects a child when you're dealing post-judgment, child support, parenting time, so that is not.
But if there's no change, for example, in the school situation, that wouldn't affect the children. But if there is a change, it does. Would that not be a sound basis to make a rule that you get a right when there's an actual change in the status quo, but if things are maintained, there is no right to appeal, you can only seek leave to appeal?
Well, then that would be changing the rule that if a motion to deny custody would not be appealable of right. I was not advocating for that change, that a motion to change custody is not appealable by right, and it still goes back to how Justices McCormick and Larson phrased it earlier, that regardless of what happens with the school decision, with the travel soccer decision, with the doctor decision, when the next important decision comes up, the parents still have joint legal custody. We didn't take away their joint legal custody, and a component of that joint legal custody is when you can't agree, the judge decides.
It sounds to me like you're saying if the exercise of the custody is ruled upon by the judge, and the judge says, in this case, I'm not allowing you to exercise your custody by changing schools. but you still have legal custody. That's not affecting custody. But if the custody decision at issue is whether you're going to be moving 200 miles away, such that, in effect, you're changing the time that the children are together, it might effectively change the physical custody that is affecting custody.
Yes, I would agree, except I wouldn't agree with the term that father wasn't allowed to exercise his legal custody on the school decision, because they tried to agree, and then when you don't agree, the judge calls it. So I would say that's a component of joint legal custody. And to build on that, to give a good example, the 200-mile would be a change of domicile. And a 200-mile would affect custody. But there are some change of domiciles that wouldn't affect custody. For example, a move from Monroe, Michigan to Toledo. That's technically a change of domicile because it's outside the state of Michigan. A move from Detroit to Windsor. That's technically a change of domicile because it's outside the country. But those two moves might not affect custody. So
Wait, so you do think, so it's not just that the judge has to say you no longer have legal custody, and that's appealable, it sounds like we all agree. But you also think that any a dispute between legal custodians that spills into a physical custody change or affects physical custody is also appealable.
I would say that.
You would say that.
We've always said that.
Well, then I think lawyers now know how to plead their legal custodial disputes, right?
Well, we also hope that the
But
courts would see through that.
Yeah, I understand.
Well, I guess I still don't understand, though. Does affecting custody require that there be an alteration in the status quo in both the context of legal custody and physical custody?
Affecting custody requires an alteration of the status quo as to your custodial rights. So if you're or denial. So if there was a motion to modify physical custody that was granted or denied, that would affect custody. If there was a motion.
That was granted or denied.
Yes. So
I guess that's where I'm having a trouble understanding how you're interpreting affecting in a consistent fashion over the expansiveness of both these terms.
Again, it's your rule, and maybe that is the rule, the part of the rule that should be clarified, because I think both Mr. Bassett and I would agree on that it has always been interpreted to be, I mean, there's ample case law on that it goes to both granting and denying.
Okay. Thank you very much.
Thank you.
Okay. Case is submitted.